You know, there are a big difference between Canadians and Americans. If you brought this person's name up amongst Aboriginal people in the States, it wouldn't ring a bell, but you bring it up in Canada, boys, conversation's going to start. Probably one of the biggest miscarriage of justice in Aboriginal legal history. Treaties were bad enough and violating various laws over the years, and the current situation in Saskatchewan and Alberta, Manitoba, but this was mind-numbing how bad it was. Today we're going to be talking about the case of the late Donald Marshall Jr. Now, Donald Marshall Jr., who was an acquaintance of many members of my family who served time in Dorchester Prison and Spring Hill in the 1970s, was a Mi'kmaq man who was wrongly convicted of murder. The case inspired a number of questions about the fairness of the Canadian justice system in the 1970s, especially given that Marshall was First Nation or Aboriginal. Now, the CBC put it numerous times in many ways, said that the Donald Marshall case is almost synonymous with the wrongful conviction and the fight for Native justice in Canada. The case inspired the Michael Harris book Justice Denied, The Law versus Donald Marshall, and the subsequent award-winning film Justice Denied. His father, Donald Marshall Sr., a very respected elder, was Grand Chief of the Mi'kmaq Nation at the time and also appeared as himself in the movie. Now, Marshall was born on 13 September on the Member 2 First Nation in Sydney, Nova Scotia. He was the oldest of 13 children of Donald Sr. and his wife, Caroline Gugu. Now, the case itself, we're breaking down the information from the Canadian Encyclopedia. It's available to any person who wants to check it out. And like I said, the aspects of the case, it's something that it's not only bizarre why he was convicted in the first place, but there was no reason, there was no intent, unless the fact was the abject racism was there. Now, at the time when his case was overturned, he was the first high-profile victim of wrongful murder conviction in Canada to have it overturned. Now, the Truscott case wasn't overturned so quickly, but he spent 11 years, give or take, in jail between 71 and 82. Now, one of the most controversial cases, again, in the history of Canada's criminal justice system. He got into a rough patch when he was younger. Now, he was a rebellious youth. He got into trouble when he was sent to a white school, and he didn't like being there because obviously the racism that white people were putting on Indians at the time was very common. Now, he got into trouble when he was sent to a white school. Again, at age 15, he was expelled from that for striking a teacher. He then fell in with a Member 2 shipyard gang, teens who engaged in panhandling and petty theft. Marshall became known to police for delinquent behavior, but again, not for violence. At 17, he was sentenced to 4 months in the county jail for giving alcohol to minors, which at the time was a major crime. Now, on the night of 20th of May, 71, in Sydney's Wentworth Park, Marshall ran into a casual acquaintance named Sandy Seal, a 17-year-old black youth. The teenagers, working together to turn someone over, encountered two men, Roy Ebsery and Jimmy McNeil. A confrontation followed in which Ebsery stabbed Seal in the stomach and slashed Marshall on the arm. Everyone fled the scene, leaving Seal bleeding on the ground. Marshall soon returned and helped summon an ambulance, but Seal died in hospital the next day. Now, the officers of the Sydney Police Department had little experience or training in conducting a homicide investigation. They rejected an offer of assistance from the RCMP, and no autopsy was performed on the victim's body. The crime scene wasn't secured or photographed, which is very commonplace now in 2022. Now, a cursory search of the location turned up little evidence, and no murder weapon was found. Now, when Marshall volunteered to assist the police, it wasn't until 2 days later that police took a formal statement. Marshall gave an account of how Seal had met two men who asked him for cigarettes. Marshall said the older man made racist remarks about Indigenous people and blacks before pulling a knife. Marshall gave the police descriptions of the man, but police didn't search for the suspects. After a brief interview with Marshall, investigators decided he had stabbed Seal during an argument. They believed the cut on his arm was self-inflicted, and he did not search Marshall's home for a murder weapon. Now, under questionable circumstances, police interrogated three other teenagers who had been in Wentworth Park on the night of the murder, and this is covered very, very heavily in the TV movie. They obtained two statements that claimed Marshall had stabbed Seal. On the 4th of June, police arrested Marshall and charged him for murder. Now, when he went on trial at the Cape Breton County Courthouse in Sydney on 2nd November 71, he was found guilty of non-capital murder and sentenced to life imprisonment, which would be equivalent to kind of a manslaughter. Now, he's in prison in the penitentiaries again at Dorchester, New Brunswick, with members of my family, not saying how he got there, but let's just keep it to ourselves. And again, in Spring Hill, two of the toughest prisons in the history of the Maritimes. In October 79, Marshall, tired of his stead, escaped from Spring Hill but was soon recaptured. Now, throughout his time in prison, he insisted on his innocence. He believed that speaking up in this way was the reason he was denied temporary passes and refused permission to attend his grandmother's funeral. It was difficult financially for his parents to make the trips to visit him, as the Marshall family received threatening and racist phone calls on a regular basis, and Donald Sr.'s business suffered. At one point, the family was obliged to apply for welfare. Marshall wrote letters to politicians seeking to have his case reopened, to no avail. Now, this was going on 9 or 10 years, but this is before the Canadian Constitution went in. But ironically, after Marshall's conviction, the second person at the scene, not Seal or Marshall, Jimmy McNeil, had come forward to tell the Sydney police that he seen Ebsary stab Sandy Seal. The police dismissed the evidence, considering the case closed. Now, McNeil's new evidence was not disclosed to Marshall's lawyer, nor to the Crown prosecutor handling Marshall's appeal of his conviction. However, in February 82, at the request of the Sydney police, the RCMP began an investigation into McNeil's claim, as well as other new information. Ebsary had admitted to a former roommate that had stabbed Seal. Ebsary's daughter Donna had also told a friend that she'd seen her father washing what looked like blood from his knife on the night of the murder. Now, in addition, Marshall had sent to the Nova Scotia Parole Board and the Sydney Police copies of a letter he received from Ebsary, in which Ebsary said he knew Marshall was innocent. In December 81, Ebsary had been convicted in a separate case following, get this, another stabbing incident. Now, the RCMP investigation revealed serious flaws not only in the Sydney Police Department handling of the case, but also in the judicial proceedings. Witnesses had been intimidated by police and had perjured themselves, giving false testimony. Evidence that supported Marshall's plea of not guilty had been withheld. Even Marshall's own defense lawyers had doubted his innocence and hadn't sought to verify his accounts of the events in Wentworth Park. Now, underlying the whole mismanaged case was the taint of racism. Some officers of the Sydney force had been known to have prejudiced attitudes towards First Nation people and Acadian Métis in that region. One member of the jury that convicted Marshall admitted to had bigoted feelings towards non-whites. Now, questioned by RCMP investigators, 3 witnesses recanted the evidence they had given in Marshall's trial. The murder weapon was found in Ebsary's former residence. The knife still bore fibers from the clothing Seal and Marshall had been wearing the night of the stabbing. On March 29, 1982, Marshall was released on parole after having served 11 years for a crime he didn't commit. Ebsary would eventually be found guilty of manslaughter in Seal's death. Now, the Royal Commission that was launched to study this included work by the Supreme Court of Nova Scotia, who officially acquitted Marshall of Seal's murder in May 1983. But the judges absolved the Sydney police and the Crown prosecutors while holding Marshall partially responsible for his own misfortunes. A Royal Commission was then appointed by a Nova Scotia Order in Council in October of 1986. The Commission said the wrongs done to Marshall were a result of racist attitudes and also incompetence on the part of police, prosecutors, and judges at every step in the process. The Commissioners declared the criminal justice system failed Donald Marshall at virtually every turn from the start of this case. Now, it failed him in many factors, and even beyond his acquittal by the Court of Appeal. Now, the Commissioner produced 82 recommendations that fundamentally changed the criminal justice system in Nova Scotia and was set as precedent for across Canada. For Marshall, however, the fight for justice had taken a toll on him psychologically, resulting in lifelong struggles with depression and, of course, drink. Silly's case was a judicial trailblazer for other Canadians wrongfully committed a murder, which later happened with the Guy Paul Moran case, the Milgard case, and also backtracked to the Truscott case. This case drew considerable interest from the general public and prison reform groups and organizations opposed to the reinstatement of capital punishment. Marshall was eventually awarded a lifetime pension of $1.5 million in compensation for his suffering. Now, became back in the news for a whole different factor just a few years later. In August 93, after catching and selling eels to near Antigonish, Marshall was convicted on charges of fishing out of season and without a license. That began a 7-year legal battle over First Nations treaty rights that went all the way to the Supreme Court. In a landmark ruling reached in 1999, the court upheld fishing and hunting rights that the Crown had granted the Mi'kmaq Nation in a treaty signed in 1760. The Marshall case remains an important Indigenous rights ruling, affirming the rights of First Nation people to earn a moderate commercial livelihood from fishing and hunting, subject only to conservation requirements. Marshall, who never considered himself a political activist, said, "I wasn't there for myself, I was there for my people." However, due to his the stress and the depression and the bad choices in his physical life, he eventually started suffering from a chronic respiratory disease. He underwent a double lung transplant, and his last years were troubled by poor health, domestic difficulties, and a financial dispute stemming from the treaty rights case. In 2001, for example, Marshall had been promised $2 million by a group of Atlantic First Nation chiefs in recognition of his struggle on behalf of Aboriginal people for historic fishing and hunting rights. 6 years later, Marshall's wife made it be known that he had only received a small fraction of the money from the chiefs. Now, in August 2009, suffering from kidney failure, Marshall was admitted to a hospital in Sydney, where he died, age 55. Now, the records of the Royal Commission of the Donald Marshall case are now available online thanks to the Nova Scotia Archives. The Royal Commission, also known as the Marshall Inquiry, appointed on 28 October 86 to examine the case from initial investigation through to trial, reinvestigation and appeal, has digitized its extensive records for the public. Now, if you want to read it, the Commission's 7-volume report includes nearly 17,000 pages of transcribed testimony that record the 90 days of hearings, the words of 114 witnesses, and the context of 176 exhibits. The audio recordings of Marshall's testimony in Mi'kmaq have also been made available by the Nova Scotia Archives as an historic treasure. The collection is vitally important, both for his vindication of wrongfully convicted Marshall Jr. and in its role in shaping the Canadian Nova Scotian justice systems that we know today. Now, the idea about the Donald Marshall case can be only understood in an aspect of context. Did we know that Donald Marshall would be this type of hero to the Mi'kmaq and the First Nation peoples across Canada? No. When he was first convicted, he was just a young Indian who was being railroaded by the system. But the majority of his life has been one of what you call study. In 2022, many young Aboriginal people growing up don't know as much as the Marshall case as those like us who were 40 and over. But this miscarriage of justice, again, led to the influential case on judicial independence in Canada called McKeegan versus Hickman as well. Now, treaty rights in Canada haven't been fully established in certain ways, and it's still, like the cases in Nova Scotia and some in New Brunswick, have been a battle over that. But it was rough for him towards the end as well. Full disclosure, of course, in January 2006, he faced charges of attempted murder, uttering death threats, and dangerous driving following a New Year's Eve party in which he was accused of attacking a man with a vehicle. The charges were dropped after both men agreed to participate in a restorative justice meeting. Now, in 2008, he also faced charges of assault against his wife, uttering threats against his spouse and her ex-husband, and the breach of an undertaking. Like I said, a very, very complicated legacy. Now, in 2010, the Member 2 First Nation unveiled a statue to honor Marshall outside the Member 2 Trade and Convention Centre in Sydney. Now, Daniel L. Paul is also suggesting renaming the Cornwallis Square in Halifax the Donald Marshall Jr. Memorial Park and replacing the statue of Edward Cornwallis with one of Donald Marshall. Now, as an Acadian Métis and a longtime advocate for all human rights for all the colors of the world and people of the world, the Donald Marshall case is close to me because at the age of 9 or 10, we're hearing rumors when the people from Lorne and Jacket River and Campbellton and the region were getting out of jail, and it was kind of saying, is Junior still in there? And Junior was allegedly, keep it yourself, was friends with a lot of people from the North Shore, from North New Brunswick, and he kind of looked out for those people in every shape or form, because what had happened to him, he didn't want to happen to other people. So I'm not saying he was a total virgin in prison, far from it, because he had some bad decisions he made in his life, but at least he was protective of certain people in prison. He didn't want to see the same thing happen to other people. So within the context of the fact, did he protect members of my family? Sure. Do I know how much he protected them? I'm only getting, information as secondhand. One of my cousins said Junior always looked out for us because he felt bad for the poor people that were in prison. I give an example of how it worked back then. I had a cousin up home. His third theft offense, he got 7 years in jail. How much did he steal, ladies and gentlemen? Allegedly, he stole less than $1,000. Allegedly, it was only $10 because it was third strike. Back then, you would throw the book against Indians, against black people, against poor people, against Métis, Acadian Métis, and that's how it was. But the Donald Marshall case, you will hopefully never see this again in Canadian history. But the problem was, Donald Marshall showed no contrition. He said, I am not guilty. And he said it for years. And how it worked back then, if you didn't, you could not be rehabilitated unless you confessed to your crime. And he did not commit a crime. And that's why, it was kind of a running joke with the feds and the police officers. But Donald Marshall did not kill his friend or his acquaintance. It was allegedly some kind of, there was allegations the guy was gay and so, he liked young men and stuff like that. Neither here nor there. He did not kill this person, and he was sent to jail and convicted because of his background. He was convicted not of what he did at the incident, but the preparation and the other incidents he was involved with of a criminal nature. You can't send someone to prison if he committed crimes and then it was around a murder and he didn't commit the murder. That's not how the legal system should work. Anyway, Donald Marshall, again, means so much to a lot of people. That's why we're doing this podcast. We're just describing the case. We don't want to glorify any of the incidents that happened. There's no good ending to this, because Donald Marshall should be still with us. All he went through, we killed him early. Because you're put in jail for 10 years for something you didn't commit. You think you're going to be happy, joy when you get out of prison. It's going to affect your physical health, your mental health, your spiritual health. And look what it did to the Marshall and Google family. I know some members of that clan, and they're nice people. They didn't deserve this, and it just, it is what it is. So, ladies and gentlemen, this is the latest on our True Crime Podcast. If you like what we're doing here, give us a like, comment, or subscribe. And from my American listeners, yes, ladies and gentlemen, it's not just the states that railroad prisoners. We do it as good as you can, and sometimes worse. Thanks for listening. Bye.